Hello and welcome to this week's special guest lecture on international humanitarian law and international criminal law. We're delighted to have with us Judge Raul Pangalangan. And I first would like to welcome you on behalf of Nilofer and myself and of the CIL eAcademy and its participants. I wanted to warmly welcome you, Judge Pangalangan, and to say how much it is a delight to have you with us. I'll just give a very short introduction so that then you can make your presentation, and then we'll have some interaction with the participants afterwards. We're really delighted to have somebody with your experience, who's somebody who's been first a judge at the International Criminal Court, where you've participated in some landmark cases, including on the protection of cultural property during armed conflict. That's an important, very important case at the ICC. But you're also a professor of international law at the University of Philippines, currently a judge at the Asian Development Bank Administrative Tribunal. And also you're just telling me about it, and I wonder how much you can share with participants. You're currently in president of the ILO Commission of Inquiry on Myanmar. You've had a very varied experience in terms of the academic background. I've noticed that you've taught at the Hague Academy. You were also director of studies, which is also something that we have in common, besides being both members, together with Nilofer, members of the Institut de Droit International, where we met recently in Angers. And so with this very short introduction, we try to, all our guests have such overwhelming CVs that we try to keep the introduction short, not to take too much time out of the lecture. But I just wanted to our participants to see how fortunate we are to have you with us, with your experience. And Raul, the floor is all yours. We're delighted to have you. Thank you.
Well, Patricia, thank you so much to you and to Nilofer for inviting me to speak at the Center for International Law. Before I start with the substance of my lecture, I think the idea of this seminar is so good. It is so good for developing international law in Asia, and in particular in developing a community of young Asian scholars in public international law. Having said that, let me proceed to my proposed topic. What I want to look at is not just IHL, international humanitarian law, vis-a-vis international criminal law. What I want to look at is the interface, the moment when those two fields actually interact with one another. And I do that within the context of the Rome Statute, and I will deal with specific examples in the case law of the ICC. This is where we start. You see, IHL and ICL basically advance the same norms, the same values. Just look at the definition of war crimes. The Rome Statute itself will quote to the Geneva Conventions, will cite the Geneva Conventions itself, and in the other parts will track the language of the convention. So it is easy to see, easy to look at international criminal law as just another way to carry out and to advance IHL. And the only difference is that in international humanitarian law, we deal with state responsibility, but with international criminal law, at the ICC, we deal with individual criminal responsibility. So in IHL, we deal with states. In ICL, we deal with individuals, and in particular with criminal sanctions against these individuals. What I propose in this lecture is that ICL is not just another enforcement mechanism for international humanitarian law. It is an enforcement mechanism, but not just. And I propose that when the norms of IHL are enforced within international criminal law, the substantive norms are themselves transformed. I go by the contrast in HLA Hart's distinction between primary rules and secondary rules. The primary rules being the substantive norms, and the secondary rules being the rules about rules, the procedural and the enforcement framework for the substantive norms. And let me deal with the most basic. IHL had long defined war crimes, going back to the Geneva Conventions of 1949. I took part in the drafting of the Rome Statute in 1998. And in the process of the drafting, I noticed, hey, what the Rome Conference did and what the later preparatory commissions did, was to define the crimes by identifying the elements of the crime. Because the moment you convert a rule of state responsibility into a legally enforceable crime against individuals, then you need the elements of the crime that is required by the nature of criminal law. Okay. So the moment we do that, we then encounter the very first glaring transformation, that the moment one enters the criminal field, then the dice is loaded in favor of the accused. In other words, if one chooses ICL as the procedural framework, suddenly you have the proof, the presumption of innocence enjoyed by the accused. He is presumed to be innocent until proven guilty, and he is proven guilty only by proof beyond reasonable doubt. That is a higher evidentiary standard than what has been applied in cases of state responsibility. In fact, in one of the cases of the Inter-American Court of Human Rights, Manfredo Velázquez Rodriguez, in a case of the desaparecidos, the court there held that, well, this is not a criminal case. We will not require proof beyond reasonable doubt. We will be satisfied with circumstantial evidence on the way this student activist was basically abducted, thrown into a car, unmarked car within the city, and saying that it fit the pattern of the disappearances during that era, during that period. In other words, the most dramatic change, the moment we shift to the procedural framework of international criminal law, is that suddenly norms which in the past for state responsibility were provable, the violations of which were provable with ordinary evidentiary thresholds, all of a sudden are subjected to a higher evidentiary threshold the moment it shifts to international criminal law. But there are actually more specific changes. I have dealt with the fact that in the Rome Statute, under the Rome Statute, suddenly war crimes were defined in terms of the elements of crimes. But look also at the sources of law under the Rome Statute, and also interpretive principles. The statute says that the first source of law will be the Rome Statute, the core instruments of the ICC. And in the interpretive principles say that the definitions of crimes will be strictly construed, nullum crimen sine lege. Now let us test these in the context of two issues. And then I will leave time for questions. You see, Patricia earlier mentioned the case in which I was involved. I chaired the trial chamber in Almaty. The religious, the head of the religious police in Mali who destroyed mosques. And in that case, we interpreted a certain requirement. The requirement was, the crime charged was attack on cultural objects. The war crime of attacks against cultural objects. And he was convicted. But there is actually a difficulty there, because in another case, the court defined attack as, in effect, a battlefield attack. And the court used the language saying, in that other case, that attack must be an act of violence against the adversary, whether in offense or defense. And therefore, it must have been committed during the actual conduct of hostilities. And then that in that other case, the Nataganda case, the trial court basically rejected certain claims of certain charges, saying that, oh, the attack on that church, it took place sometime after the assault, and therefore not during the actual conduct of hostilities. And so that is a very restrictive definition of the word attack. We did not follow that in the Al-Mahdi case. And so this is a debate which transpires within the context of norms of IHL, which give protected status to religious objects, cultural and historical and religious objects. And the debate here is that if IHL regulates the conduct of hostilities, jus in bello, then therefore the attack against the church in the Nataganda case and the mosque in the Al-Mahdi case should have been committed in the course of the battle. And the distinction being made is that if the destruction of the church or of the mosque happened after the battle had been won, then it is not, it does not satisfy the requirements of the crime. Notice that from a purely, from purely IHL standpoint, the object of IHL is to regulate the military operations to minimize the human cost, but while respecting the military, the military objectives of the armed combatants, of the armed groups. And so the Nataganda ruling saying that the attack must have been committed in the actual conduct of hostilities will be valid within the context. What you see, the international criminal law is not built upon that concern between two competing armed groups. It is built upon the principle of holding the accused liable and answerable for the crime that he has committed. And if one takes into account the changing nature of warfare, then the natural consequence is that you don't construe the term attack so narrowly, and you will construe it broadly to cover the range of violence committed in relation to the armed conflict. So, from a purely doctrinal criminal law standpoint, the reasoning is that the only nexus required under the Rome Statute is a nexus to the armed conflict, not a nexus to a specific battle. That is the doctrinal reason. The normative reason is that the broad meaning of attack is required today because of the changed nature of warfare. That in the past, the destruction of churches and temples was part of the prize of war. It was the reward for the victors over the vanquished. And yet today warfare has changed. The destruction of the temples now is part of the conduct of hostilities. It is part of it is the way by which one army destroys the other group's will to fight, by destroying the temples where they worship, the community centers by which they marshaled the sense of community, the sense of nation. That was my first example. The interpretation of the meaning of the word attack within the context of IHL, such that if the main concern of IHL is to regulate the conduct of the two warring groups, to minimize the human cost, but while respecting the military necessities and prerogatives of the armed groups. In contrast, in ICL, the goal is different. The goal is simply to look at the accused and to determine whether he is guilty of the crime charged, and to construe the crime charged against in accordance with the language of the statute, which required simply a nexus to the armed conflict, not a nexus to a battle. And more than that, to vindicate the purposes of the Rome Statute, which is to end impunity, and impunity here being allowing the accused to get away with committing violence within the context of the armed conflict, not necessarily in relation to a specific battle. That is the first. Let me proceed to the second. The second is this. There was a very interesting case. My last case in the court was on child soldiers. The typical scenario is that the kids, boys and girls, are abducted on their way to school. The boys, typically 10 years old to 12, are made into child soldiers. In the latter case that I handled, the Ongoen case in Uganda, the girls were made into forced wives and subjected to repeated rapes. There was another case. I took part in that case, not as a member of the trial chamber, but as part of the appeals chamber. It was an interlocutory appeal. There was a very interesting defense. The accused said that the accused is charged of having raped the women child soldiers in his army. That was the charge. He filed a challenge to jurisdiction, an interlocutory appeal. Went all the way to the appeals chamber. I was designated to be a member of that, to be an ad hoc member of that appeals chamber. His defense was this: he said, I'm being charged of a war crime. But you see, the charge is I raped my own child soldiers. And in the traditional definition under the Geneva Conventions and the definition of war crimes, these are crimes committed against the opposing army. And therefore, if the charge against me is that I raped girls, child soldiers within my own army, then there was no crime committed. So he challenged the jurisdiction ratione materiae of the court, went all the way to the appeals chamber. The difficulty there is that technically, what he said about the Geneva Conventions and war crimes is correct. It is war crimes are crimes committed against the enemy. And if he raped his own soldiers, the way he stated it, then my victims were not protected persons under the Geneva Conventions, and therefore there was no crime that was committed. I'm actually, when we began the case, I confronted that argument. It really struck me. If we apply IHL in this case, he would get away with it. But you see, first, and by the way, he also invoked in his favor the nullum crimen principle, that he says, well, and if you go strictly by the language of the statute, therefore, I'm being charged with a crime that is not contained within the statute. Let me fast forward to the end. The trial chamber ruled against the accused, and the appeals chamber upheld that position of the trial chamber. The argument being that, yeah, sure, if it is a war crime, and you apply in the jargon of the decision what they call the status requirement, the status of the victim, of the child victims, their status as protected persons, then there is no crime. But both the trial chamber and the appeals chamber rejected the defense, saying that status requirement does not appear anywhere in the Rome Statute. In other words, if you go by the sources of law, the first reference is to the Rome Statute, not to IHL writ large as customary international law. The Rome Statute contains a clause saying that acts committed in violation of grave breaches under the Geneva Conventions will be punishable as war crimes. But both the trial chamber and the appeals chamber also said that the acts committed were punishable under other provisions of the Rome Statute that were not subject to that status requirement. There are, of course, other principles that were cited by the court. One principle is that, you see, the child soldiers were abducted by the accused, by his army. They were raped while they were in that army, and the court cited the principle that one may not profit from his own crimes. It also recognized the principle that assuming that these girls were actually child soldiers, they were conscripted against their will. In other words, they were not child soldiers by their own choice. And also, it cast a question on the issue of whether they were actually genuinely combatants if they had military status by virtue of their being child soldiers, having been conscripted into that army, or conversely, whether in fact they were not taking direct part in hostilities simply by token of their being labeled child soldiers by the army of the accused. Now, taking one step back, in both cases, what the court applied was textually the language of the Rome Statute. In other words, it acted as a proper criminal court. But in doing so, the court actually deviated from the established principles of IHL. And how does one explain this? As I have said earlier, choosing the enforcement regime, well, each enforcement regime has its own dynamic. The moment a certain norm, even if the norm is the same, whether it's IHL or ICL, the moment they are enforced in a specific enforcement regime, that norm itself is transformed and acquires new characteristics. In the first example, the meaning of attack, the dynamic within IHL is to regulate the conduct between two armed groups, and therefore it construes the word attack narrowly within the context of that clash of arms. In other words, it regulates the hostilities between the parties, and when the hostilities are over, it can't regulate anymore. There's no IHL required in the absence of an armed conflict. In the absence of hostilities. And therefore, in their construction, the term attack must be construed narrowly in relation to the conduct of hostilities. In contrast, for international criminal law, the term attack is construed in relation to the nexus of the existence of an armed conflict, fully recognizing that there's a full range of acts of violence committed in the context of an armed conflict, and that if one looks at the changing nature of warfare, the historical context in which a rule is being read, it is perfectly understandable that the term attack should cover the full range of violence committed leading up to the actual hostilities and even after the hostilities. In fact, there was a concurring opinion by the president of the ICC in that decision, where he says, look, and he took a particular reference to the concept of the ratissage, opération de ratissage, the search and sweep operation, which is an operation to make an area more secure in the aftermath of the battle, in the aftermath of the capture of that territory. And he asks, will we consider the ratissage as not part of the hostilities because by then the battle had been won? Or should we say that it is still part of the capturing of a place because the capture is not complete until you have fully carried out the ratissage, which, by the way, was the interpretation of the Yugoslavia war crimes tribunal. So, for the concept of attack, there are two interpretations: one specific to IHL, one specific to ICL. The differences being, in the first, the goal is to regulate the conduct of hostilities between two armed groups, and in the other, the purpose is to end impunity and to punish the accused for a crime that he has committed. The same thing with the requirement that a war crime must be committed against the army of the opposing side if it is enforced within the context of IHL. Then of course the classic definition applies, and it will be rather restrictive. But if it is applied in the context of ICL, the so-called status requirement is not applied by the ICC, because that status requirement was not listed as an element of the crime in the court's core instruments, referring to the Rome Statute and the elements of crimes. Okay, just by way of conclusion, we began by looking at the humanitarian norms contained in both IHL, the Geneva Conventions and the additional protocols, and the humanitarian norms being protected as well by the Rome Statute and the ICC. And I explored two issues to demonstrate that the same norms will actually be transformed depending on the enforcement regime. And I would like to close with this point. And those transformations are specific to the core purpose of that field of law in IHL, which is to regulate the fighting between two parties, and in ICL to hold the guilty person accountable and responsible for the acts that he committed. I will close on that point, and I welcome questions.
Thank you so much, Judge Pangalangan. And this was really, I think, an extraordinary opportunity to hear from somebody who's had the experience in practice of direct contact with these two different bodies of international law, because I think that for most of us, even if we study IHL and international criminal law, these nuances, as one of the participants was saying in the chat, these nuances, I mean, the different objectives, the different criteria, the different standard of proof, the different elements, and how they interact together is extremely interesting, and I think this is certainly one of those things that you cannot learn just from reading books and academic papers, but you really need to hear it from somebody who's had the experience of the interpretation and application of the law. While I'm waiting to see, I mean, there's a comment in the chat to say how honored they are to hear from you about the nuances of the Ongwen case in Uganda. Perhaps while we wait for the ice to break, maybe I'll ask a question, because I was also thinking on the Madi case. What were the defenses that the justifications that Al-Mahdi presented? Because you mentioned the justifications for Ongwen, but because I was thinking, I mean, of course, that would limit, for example, the possibility in ICL, the possibility of using military necessity or military advantage as a defense, as a criminal defense. So I don't know all the details of the Al-Mahdi case. I was thinking, what were the defense that Al-Mahdi presented, if any?
Thank you for the question, Patricia. But before I do that, I also want to acknowledge the comment of Gerald. And I didn't realize the reach of our seminar, Patricia, that we have participants all the way from Uganda. And in fact, Gerald, I spent the last more than 2 years of my life in the court on the Uganda case. I didn't realize I would learn so much about your country in the course of that trial. Okay, Patricia, in response, well, the defense, the arguments that I mentioned to you, Patricia, were more from the academic commentary, and because Mr. Al-Mahdi eventually entered into a plea bargain with the court in exchange for him testifying in another case. And by the way, these were not on the record of the case when we were hearing it. These are all from outside accounts, and also from the after the fact development that one of his cohorts was eventually arrested, charged before the court, and that he was testifying against his cohort. So the argument did not come from him. I can confirm from my end, Patricia, that the possible argument that you thought of military necessity was not present, and in fact, that is one argument that, had it been present, might have strengthened his case, because then he will say that, well, I attacked it. It had lost its protected status at that stage, and therefore it was a legitimate act on my part. But let me just go into a finer point. You see, in the subsequent case where they construed attack differently, Patricia, what they did was, well, you know, as with trial chambers, they tried to reconcile their ruling with the earlier ruling in Al-Mahdi. So they just had a footnote there. And what was interesting is that they said that, if you read between the lines, basically, in the Geneva Conventions in IHL, there are there's protected status, and there's the loss of protected status, military and non-military. But even in the non-military civilian box, they suggested that the wording was, of course, there is special protection afforded to cultural objects. And in our case, they were saying, what we're dealing with are attacks against certain persons, and if the attack is against a person, we have to construe the meaning of the word attack narrowly. So when they say special protection for cultural objects, then it suggests that there is an additional reason for the protection. In other words, the classical reason is that an object, a civilian object, is protected because attacking it makes no military contribution to the prospect of winning the battle. And therefore, if it has no military value, it's got to be civilian. And they seem to suggest that for protected cultural objects, well, including museums, churches, schools, libraries, there is a separate interest being protected apart from the fact that they don't, attacking them won't contribute militarily to the other side. And if one reads it that way, then the protection for libraries, schools, churches, and museums would be the cultural value placed in these objects. So again, just to summarize, it's a long answer, Patricia. The calibration of the scope of the term attack. These were arguments which came more in the academic in the academic literature. And I think in the latter case, where it was construed narrowly, it was more, I take it, a response. In other words, they knew that there was an academic debate going on, and they were taking their post within that context.
Yeah, thank you. So we have a question from one of our participants, Ajema from Ethiopia, who's asking in the chat, in interpreting core crimes under the Rome Statutes, are international human rights instruments like the Genocide Convention significant?
Okay, Ajima, thank you for your question. Well, let me start with the easier part. Are instruments like the Genocide Convention significant? Well, the court has jurisdiction ratione materiae over 4 crimes: war crimes, crimes against humanity, genocide, and the crime of aggression. So the easy answer is yes, of course, the Genocide Convention is significant. The definition of genocide is contained in the Genocide Convention. There is also which is mirrored in the definition in the Rome Statute. But let me proceed, Ajima, to the more interesting point. You asked about broadly international human rights instruments. Well, I've got to tell you, in international criminal law, you will often see the word human rights mentioned as such in the Rome Statute. And the irony is, the first human right, more precisely, the typical human right referred to in the Rome Statute is actually the right of the accused to a fair trial, the right of the accused to file an appeal, the right of the accused to confront his witnesses, the right of accused to speedy justice, the right of the accused to be presumed innocent until proven guilty. In other words, normally people will assume that the term human rights in an international criminal court will refer to the human rights of the victims. Well, of course, the human rights of victims are recognized in the Rome Statute, but they're not first and foremost. The moment human rights are cited, they will most probably pertain to the rights of the accused. There are human rights will also be mentioned in relation to the admissibility of evidence, especially the human right to privacy, and that will pertain both to the accused and to the prosecution. But the misconception is that human rights is all over the place when it comes to the Rome Statute, because it's the human rights of the victims that is at stake, but not quite. It is more typically the rights of the accused. I see the hand of
yes, exactly.
Selwyn.
There's Selwyn. Please, if you want to ask a question, go ahead. From Namibia.
Oh, thank you so much, Prof. and Judge. My question simply is, when delineating the proper understanding of what attack is under ICL, is it safe to assume that the judges enjoy a higher sense of discretion in comparison to the restrictive rules under IHL?
I'm sorry, Selwyn, this is an interesting question, but you lost me there somewhere. Can you say it again?
Judge, the question simply is, when one considers a proper understanding of what attack is under ICL in relation to the rules and norms of the Rome Statute and the ICC, and considering how broad that is in comparison to the restrictive nature of what attack is under IHL, can one safely assume that the judges then assume a level and a sense of some discretion, like a wide sense of discretion, when delineating the rules of ICL and to answer and unpack what attack means under ICL.
Yes. Well, thank you for that question, Salvi. Very interesting. I've got to tell you, in the appeals chamber decision, in that other, for the other issue, not the definition of attack, the definition of war crimes in relation to the child soldiers, the kidnapped girls, where Selwyn, following the model that you mentioned, where the court might be said to have exercised its discretion rather widely. The court actually had a paragraph saying this is not judicial activism, and they used that word. This is not judicial activism on our part. We are simply construing the language of the Rome Statute. We are textually faithful to the statute. So, and I will say the same thing if you read the broader definition of attack. I would say that it was purporting to be similar to that ruling, but it was not explicit about saying that we're not undertaking an act of judicial activism here. But it's my way of saying, Selwyn, that the concern that you raised was confronted by that other court. Now, it doesn't pose a problem, Selwyn, because if you track the reasoning, I think it's typical of, especially of criminal courts anyway. The reasoning will be rather, they will carefully hew to the text of the law. That is why the operative clause for both decisions was that the only nexus required is to the existence of an armed conflict in both cases, because that is the only nexus requirement. There was in the destruction of the mosques, there was no requirement of a nexus to a battle. It was a nexus only to the larger armed conflict. In the other case, the child soldiers, the court also said the only nexus required is to armed conflict, and there is no other requirement like the status requirement that was being proposed by the accused. But thank you so much for your question, Selwyn.
Thank you. I don't see any more requests for the floor or questions in the chat in the Q&A. I'm just double checking. So I think also we have, today it's a double lecture. So in 1 hour, we will have another guest lecture that was postponed from a couple of weeks back due to health reasons. And so we're having a double lecture, so maybe it's time for us to leave the participants go for a short break. And we actually are let me check, because there's a there's a question about reading materials for today's lecture. We can work that out perhaps with the text of the decisions and something else you might want to share with us, Raul.
I can do that.
Follow that up. Yes, wonderful.
I can send the text of the decisions that I cited.
Excellent. I think they'll be very welcome by the participants. And again, as I said before, this was such a unique opportunity, not only to learn for somebody that had hands-on and that type of experience that you can only get by doing that, but also for all our participants as young and engaged international lawyers to develop their legal reasoning, because it's very different when you're being an academic and making an argument, or when you're sitting in the in a court, and when you really have to interpret the law that you're going to apply. And so I'm very grateful. We're getting a very nice comments in the chat, and we will indeed provide, with the help of Raul, will provide and the reading materials, the text of the decisions to our dear participants. So with this, Raul, again, very warm thanks. We're very grateful. What we can do in Zoom is do our virtual round of applause.
Well,
and thanks so much, and also thanks for your kind words to the Academy, because that's really the purpose of developing this network and sense of community also for Asian international lawyers.
well, thank you also for inviting me to become part of the work of the Center for International Law.
Thank you so much.
Okay.
And see you soon.
Bye-bye. See you soon.